Oh, hey,
Oh wow.
just doing some
Yeah.
light reading here,
Like
partner.
we have so much going on. I've been, as you say, I think I started here at 8 o'clock this morning with the court TV segment on our exclusive that we had in ASAP Rocky about the judge and about whether or not they were to consider or they were asked whether the prosecution was asked whether they wanted to go forward twice, and we have emailed both the prosecution, the DA's office, and we've emailed. And texted Joe Tacopina's office, and we've got no response from anyone. Very interesting, I find, because it's a gag order, I guess.
But
And,
even the attorneys in the civil matter, Ben Chu, Camille Vasquez, have been reached out to by us, and
right,
and they're not gagged, but they have a very important interest in this ASAP Rocky case, and they have not responded as well.
yeah.
While we're talking about it, fantastic job this morning on my old Stomping Grounds Court TV with Julie Grant. Did a great job, and just congratulations for me. Just getting up at that hour to watch was a victory.
You getting up that hour, I had to be all made up and everything.
I know.
There and all that kind of stuff. And I'm still here. I'm the same things I was in. I just added the earrings because I was a little late this morning.
Let me talk about. We've got a lot of comments. We've over this ASAP case. We've had a lot of stuff in part because of our tips and our sources, but so much. And we'll get to this in one of our latest comment shows. We haven't done a comment show in a while. But Linda, I love your glasses. Linda, you're dripping the bling. And I really started to feel, like, the ugly stepchild. So check this out. Red T-shirt, huh?
To match your red chair.
Pretty good.
Is that to match your red chair?
Hey,
behind you. Look at that.
I have to choose my battles, and winning a sartorial battle over LKB is just not happening.
Well, someone suggests that your skeleton in the background should have a top hat. So maybe.
Well, he's got the winter hat on now. He's got the winter hat. So maybe as we move into spring, we'll replace the chapeau.
Maybe a top hat and tail.
Hey, one more thing that totally apropos of nothing. Ready for this? Okay. We know that we've kind of bonded, right, with Miss Shorty down under, and I just got the Rams schedule for 2026. Guess where they're going to play? Australia, mate.
Are you kidding? The NFL's moving to Australia?
Yeah, well, they've been doing these, European games for the last few years, but now down under. So, warning Miss Shorty, I will find you because I haven't been there in a few years, and I would love a reason to go. Like, hey, my Rams are going to play there. Yeah, so I wonder where they would play. They must have. I'm not familiar. They have a big soccer.
Well, can we ask Miss Shorty? She probably knows.
Where would they play? Where would the NFL play if they come there? I'm assuming it's going to be Sydney. I didn't look closely enough, but I think it's going to be Sydney. Yeah. Anyway, that's all the strays that I've got. I know we got a lot of stuff to get to. So
we have a lot of stuff to get to today. So let me just say, we're going to do ASAP Rocky at the end of the show. Nia will be on again. Our guest host will be on to talk to us about that. We have some interesting issues, some interesting questions. I know I love Miss Shorty, says here comes drama. Yes, we do too. We've all gotten to love Miss Shorty. I don't have the courage to vape like she does because I don't do smoking, I don't do drinking. What am I going to do? Actually, I do Cosmopolitan and a little champagne every once in a while, but that's really not drinking. That's like it's like for
juice.
Yeah, well, it's like Hawaiian punch. To be honest with you,
with the accent on the punch.
So with the accent of the punch, yeah. So we're going to talk about a punch too. We have a case that we're going to talk about second, and that's going to be the case not guilty in Judge Bev's courtroom today. The case of Penny McGee, right? Penny McGee. Do I have that right?
Penelope. You may call her Penny. Penelope McGee.
Penelope McGee. So and that involves around maybe a punch, maybe not. We'll see. I have some real interesting stuff about that. But she was found not guilty. We'll talk, and we're going to have one of our viewers. I hope she's going to get on here who actually told us to look at the case. And so we did look at the case. Thank you very much. Here comes drama for the interview. I'm hoping that my co-host here, who knows how to cut these things, and he doesn't cut, just post it. We'll have it posted tomorrow. It's there for download. It'll be gone pretty soon and on our Justice Serve TV website, and then we'll tweet it or X post it out also. And so that's it. And we're gonna start, before we get to those two cases, with a big directed verdict, something that maybe here ASAP Rocky we'll be talking about this week. We don't know, but it was a great directed verdict in a case, in a case actually in Georgia, and it evolved around a tragic situation. Remember the Ahmaud Arbery case, Michael Bryant, where he was killed. He was tracked down by the McMichaels, the father and son team, and then they're in jail. They're in jail for life with the
As
state.
is the guy I really think was just guilt by association was Roddy Bryant, who
Right.
had the damning video
Evidence. I
he
thought it was
recorded
great.
on his phone. They were so happy to turn it over. Look at this. Look what happened. Guilty. Yeah, and I was down there for that case in lovely Brunswick, Georgia, a tiny little town. And we were ready to go. We had it on the board in pencil to go down and follow this case. But then the judge said, oh, wait, let me go to a clip here. Oh, wait, I don't have it.
It's the prosecutor. It's the prosecutor, right?
This is the prosecutor who was initially involved in the investigation.
Jackie Johnson.
Jacqueline removed herself because of an apparent conflict because Gregory McMichael had called her within an hour of the incident and said, might have a problem here. And then she appointed somebody in her stead that also had a conflict because had worked with Travis McMichael, the actual shooter. So the charges against her were, I think, let me get the official word here, because it's kind of oddly, violation of the oath of her office and also obstructing justice or hindering charge.
And that was dismissed. Excuse me, I dropped something on the floor.
Yes,
as I leave you again, pick it up.
That was dismissed before today. That was dismissed.
The judge found, she actually testified. I think the judge found not a scintilla of evidence. Not a scintilla. He said.
Yeah. How much is a scintilla again?
Oh, you can't even see it. I mean, I don't drink because I would get drunk on a scintilla of drinking. But that's how I look at it. But unusual, right? Unusual. A big loss there. And then they say, okay, well, there's still the major charge, the felony charge, and all of violating her oath of office, which is an interesting charge. And today, the judge didn't even send the case to the jury. The judge, by the way, had some wonderful words apparently with the family of Ahmaud Arbery. Said why he had to do this, right? And the case was dismissed on something in Georgia. And we're going to have Doug Weinstein on tomorrow, who'll explain Georgia law better than I. I just read about it. It's something called the demurrer, which means that even if everything in the criminal complaint were true, you can't be guilty. And the reason why is that the oath of office that was pleaded in the complaint charging her with a criminal action was the oath of office she took when she was going to be in a temporary position there. It wasn't the oath of office she took. Yeah. It's very technical when she became a prosecutor. So she couldn't be charged with violating that oath of office because that oath of office didn't apply to her when she was the prosecutor, the lead prosecutor at the time of the Travis McMichael Ahmaud Arbery incident. And so it was very technical. It had to be dismissed. Brian Steele, remember him, Brian Steele? From the YSL case, represented Jeffrey Williams, YSL. He represented Jackie Johnson. He made the motion, and it was granted. Now, we've been kidding around online in X Twitter with somebody who pretends to be Brian Steele. We try to get we say we want to get him on the air, but Brian Steele doesn't do interviews. So the only way we can talk to a Brian Steele is talk to a phony Brian Steele, and he's very funny about it. He actually loves our posts and all sorts of stuff like that. But so we're going to talk more about that tomorrow night. Yes, Doug will be back. The great Doug. Will be back again.
Let me throw in some demure reflections here, because in California we have the demurrer there. It's unusual to happen during trial. It really doesn't even happen up to the brink of trial. It's basically the equivalent in federal court would be a 12B6 motion, failure to state a claim upon which relief can be granted. Right. And it basically says if everything in here is true, you got bupkis, you got nothing. Right. So that same standard applies ultimately in a directed verdict, right? But to see it happen and unfold as it did, Brian Steele's a genius. He probably looked at something most people have just skipped right over, right? That is the specific oath that was taken.
Right.
You and I, we take oaths, right? We're officers of the court, and that's pretty much standard for an attorney. It doesn't change much over time. But if you're going from office to office, as Jacqueline Johnson was working for the government, certainly it could change. And so he was smart enough to dig into that and say, aha,
Yeah. With Keith Adams. And I had the situation when I was a prosecutor. I was a prosecutor in Monmouth County, New Jersey. You had to take an oath, right? You sworn in, you take an oath. And then the prosecutor left because it changed. It was a new prosecutor was being appointed. And while there was the legislature was considering the new prosecutor, we became temporary attorney generals. So the attorney general came in. We had to take an oath to be an attorney general, right? Temporary attorney general, basically, you were, And then when the other prosecutor came back, a new prosecutor came in, replacing the old prosecutor, we had to take another oath to go back to being prosecutors in the county.
Right.
So it'd be like the situation if I were charged with some wrongdoing on my temporary attorney general oath. That couldn't apply because I wasn't acting as an attorney general. I was acting as a prosecutor.
Yeah, and
it
it's
was very interesting.
it makes some people mad, of course, because it never gets to the merits of the actual case. It is such a technical objection. But I wonder if, and we could talk to Doug more about this tomorrow, what's the sense in the community there? Do they feel like they didn't get enough of their pound of flesh with the McMichaels brothers and Roddy?
Right.
I'm just very curious if they feel like they've been robbed of justice as it relates to this woman.
Yeah. And, we've also been talking to, and I don't know whether he can come on, Jason Sheffield. He represented, I believe, Travis McMichael in the state case. Be interested to see his take on this because, you have to, you get the client that you get. I mean, it's, sometimes you're assigned the case you get the client to get. And as attorneys, we do the best we can for everyone, even if they're guilty, because sometimes they're not guilty of the top crime. I explain that to people. Maybe somebody charged with murder is guilty of manslaughter. They still need a defense attorney. And they need a win, and the justice system should work and charge people and convict people appropriately. So more on that tomorrow night, Michael Bryant, because you and I are not Georgia attorneys, although I feel like we've become one.
Although, it's kind of I've kind of adopted it in some ways. Not Fulton County. No, I'm trying to avoid Fulton County, but it's a lovely state.
Yeah. And by the way, the reason why we know all this is infamous Sylvia was in the courtroom because the court there again denied streaming of the case. And I say again, as I said this morning when I was interviewed on Court TV for the Rocky ASAP case, is that I was on a panel last week with the chief judge, the Court of Appeals here, our top court, it's like the Supreme Court, Rowan Wilson last week. And we discussed on the whole panel with everyone, former attorney generals for the state of New York, that it's openness, that you need that transparency so that people have faith in courts. If they don't have that transparency, hint, undo the gag order in ASAP Rocky, you don't see what's going on. So now there is a case that we do see what's going on, and we've seen what's going on because we've had a wonderful chatter here. And she actually is waiting in the green room to talk about the Penny McGee case.
She mentioned it last night, and we're like, what? I don't know, because we've kind of been doing other stuff. But even though we were up at Karen Reed last week, and I believe they're going to be back in that same courtroom tomorrow for some matters.
That's Miss Bev. That's Judge Bev's courtroom,
Judge Bev, who we saw in a very different light today. And last week I was ragging on her, saying she never rules from the bench. She just never. What a shocker that today she actually did in about as final way as you possibly could. So thanks to our audience member. And do we identify her as who she really is?
She's agreed to go on the effect. We did all the research, and I watched the medical examiner testimony, and I was horrified. So we're going to do a little bit of that, but I want to bring Joanna White from our green room, our backstage.
Is she incognito?
Without her,
hello.
She may be incognito, but I give her credit because she was in court all the time, and she brought this case to our attention. And she said it's ridiculous, and she felt very strongly about it. So we tracked you down because you go by the name of
that was interesting.
Moon. What was your stage name when you're here in our chat?
Well, my YouTube channel name is Moon Goddess.
Goddess.
And when you chatted, was it Moon Goddess or was it Moon 14 something?
Moon Goddess 1444, I think, or something. My mother's date of birth.
Okay.
There's always a good story behind these names.
Yeah, and so because of you,
looking good in red, hun.
Thank you.
Yeah. So we tracked her down, and she would like to remain incognito on the stage, but you can hear her and you kind of see the little and go look for her. Yes, I know it must have been a surprise when you got my email. Hi, how you doing? but we thought that you should get the credit for bringing this to our attention, because or else we wouldn't have done it. And you're right. Tell us why you felt so strongly about this case. What was the case about and what happened?
First of all, I can't really take too much credit because I knew nothing about the case. My local media here in Boston, Massachusetts hasn't shown anything about it. I didn't know nothing. It was Melody Little, actually, whose community on YouTube that I am a member of. And she's a civil attorney out of New York, and she has a YouTube channel, Melody Little. And she has a really great legal analysis breakdown. So I like listening to her. I gained so much. And she has a really nice community that she's building on YouTube. But what got me going with this case,
then you joined our community.
Yes, exactly. Well, there's a couple of YouTubers that I'll follow. You guys are one. I enjoy listening to your dialogue. And it's up my alley. I can't go with everybody. When I'm following somebody and they're giving me information, especially regarding true crime, I want facts. So in the Penny case, I knew nothing about it, but as I started to begin to learn the facts through Melody's commentary in her channel, I realized something's very wrong. The case should not have been brought.
Now you're talking about Penny McGee, not
Penny
Daniel
McGee.
McGee. Right. Okay.
Right. Yeah. I just feel like the prosecution, I don't know what they're doing over there in Norfolk County, but Karen Reed case, I felt strongly about that. That case should not have been brought. And so when this case came along, I really was like, okay, something's just not right. How do you make a case out of nothing? And when you listen to the facts in this case, it's easy to see that she didn't have an argument with her husband or ex-husband, and then he had a heart attack because she was yelling at him.
So let's bring our viewers back to this. She was charged with murder because she went to manslaughter. Okay, she went manslaughter. She went to her ex-husband's house, who was some big politico in the past. His name
he was involved with Dukakis's
back in the day.
And she went to her ex-husband's house. We'll talk to her because they were evicting her from her own house, and she went to speak with him. And as you could imagine, apparently there were words spoken. And then during the middle of the altercation, of which there initially was a one recitation, but the middle of the altercation, where apparently, and we'll hear it on cross-examination, he was grabbing her hair, according to what were in the police reports, and pushing her down the hallway and pushing her into the refrigerator and all. The prosecution said no, that didn't happen. They relied on her daughter's testimony and claimed that her mother hit her father, and then the fight escalated. But in any event, that in the middle of this, he had, as he's there's no doubt that he's going down the hallway dragging her at the point, he has a heart attack and he dies because he's older and he has heart trouble, a lot of heart trouble. He has diabetes. He's infirm. And then, besides shoving a little bit, her hands didn't touch him. I think she may have slapped him at some point, but he was grabbing her and dragging her, and he dies, and they charge her with manslaughter on the basis, and you'll hear it from the medical examiner. I heard it, and I know you were in court when this happened, that there's something called the National Association of Medical Examiners who have a guideline, and they say, somebody is in the room when somebody dies, and there's anything, even words like "boo," and you die.
Oh,
I kid you not. I kid you not. Right. Michael Bryant just dropped that. You are going to be charged with homicide. And this is the same office that apparently has been dealing with the Karen Reed case, and also dealing with the Sandra Birchmore case out there, from what I read. And so the defense attorney who was appointed is a very good defense attorney who's also involved in all these cases. And you said he was really good, right, Joanna?
Yes, he is. Larry Tipton, he's really good at what he does. He had an awesome closing argument today. Melody's on my brain. I love her so much.
Well, you're going to be saying that about us too. Linda Michael's on our brain.
Penny she didn't testify. I thought that was a good call for him to have a bench trial with Judge Beverly Cannone. I didn't have the best view of the judge going to the court, but being there yesterday, I realized how much I think she's pretty pleasant and she's fair. And if I was in that situation as Penny McGee was, I would have chose the bench trial in front of Judge Bev. And
but
so
what was it, Joanna, that made you said that this case was very important to you? Why?
Well, because I live in Massachusetts, but I just want to make a correction real quick.
Okay.
Penny was actually living at her ex-husband's house.
But he was going to be evicted. That's right.
No, right. She was being evicted from a home that the family owned. Right. It was the parents passed it on. It was a trust. It was owned by the trust. The ex-husband's brothers were the ones evicting her.
Got it.
And then you have to take in an account to her daughter did not have the best relationship with her. And so there was some ongoing issues there as well. So when Penny went to the house, once we reviewed the documents and we looked at the police reports and such, she went in there. She might have been very angry that she was being evicted by email, and they might have had some words. They were sitting on the couch. When he yelled at her to leave, she gets up to go leave, but he wants to grab her hair and starts throwing her around the house and doing that tugging thing. And she could have hit him, but she didn't. If it was me, I would have been fighting him off of me. But the whole idea, I just felt like this man had a lot of health issues. And we can't say what kind of health he was in and if that didn't contribute to his death. I think his anger was his own demise.
I think there was something interesting in this case that reminds us to understand that homicide has two meanings, one for the medical examiner and one for the attorneys.
Oh, medical examiner.
and because, any medical examiner, when they decide manner of death,
very good though.
They say homicide, that doesn't mean it's a criminal case. That means in their mind, it's the simple one taking of life by another human. That's what it is. It could be justified. Right. It could be self-defense. It could be all these things. They're not making a legal determination. They're just making a medical determination. I think what we should do, again, for us, we were kind of new to this, very new to this until you brought it to our attention, which we appreciate. I have a couple little clips here. The first is when you mentioned the daughter, and she was on the stand in part because she's the one that called 911. So this is a pretty intense. I think I got the right one here. Let's check. This is a pretty intense call here. How do we like it so far? Where did that go? Oh, there it is. Hold on. I'm sorry. There we go.
This is the 911 call.
What's going on? Okay, what just happened? I didn't even handle it. What just happened?
So, not as intelligible as you might like, but you certainly get a sense of the fear, the drama, and that's the daughter there who made the call.
She was yelling at the dad to stop. And so she obviously saw the dad grabbing onto the mother and throwing her from the wall to the refrigerator into the front hallway. And I just felt like if he had stayed on the couch and asked her to leave, after meeting her yesterday, I'm sure even if she was upset that she would have got up and left. She's a really pleasant woman, and it was just obvious that it was a bad situation. The family dynamics wasn't the best, but by all accounts, Everybody I met in that family yesterday said that he was a good man and he was a good father.
You know,
And
toward
they
the end of
must
that,
have had a good relationship because Penny was his power of attorney. She took care of him after 2 recent car accidents. I mean, there's a lot of dynamics to this case.
toward the end of that call, we hear, we need an ambulance. So it sounds like the fight is underway, or the confrontation, the altercation, and then he must have gone down.
He
And then
collapsed.
we hear,
And she
we
was
need an
doing,
ambulance.
and she was doing CPR.
And she did, and Penny did CPR.
She immediately
Right.
did CPR. Now, the medical examiner determined that Cyrus's cause of death was cardiac dysrhythmia following an altercation in a person following an altercation in a person with hypertensive and arteriosclerotic cardiovascular disease and diabetes. So just so you have that.
So let's look at some of this cross-examination. You know, we've kind of laid the groundwork. We know that her testimony was all of these things existed, the cardiac issues, he had diabetes, all these medical issues existed.
He was one cheeseburger away.
Okay. And so her opinion basically was that altercation pushed him over the top and therefore was a homicide, and the prosecution.
I love our jurors.
The prosecution ran with it and said, "Oh, well, let's make this not just a medical homicide. Let's make it a legal homicide, illegal homicide, in this case, manslaughter." So what we have for you here is just a bit of the cross-examination, which I think is helpful, not just to see Mr. Did you say it's Tipton? Is that right? Is that the attorney?
Tipton was the attorney, right?
Yeah, Tipton, yes.
Okay.
He was awesome.
Angry in the presence of another person. Therefore, this becomes death at the hands of another. A second person is involved in the situation. And it is a medical definition, not a legal definition.
I understand that. But the government is relying on you to make the connection of who's responsible for the precipitating event that resulted in a cardiac event. Would you agree with that?
Yes.
And so if Mr. Savage became belligerent and became angry and had a flood of hormones just because Miss McGee's in the same room,
but there was a witness.
She's responsible?
There is a witness who said that they were interacting with each other. This is not a situation where she was sitting in the room not interacting with him. Therefore, there were two people involved in the discussion per the reports that are part of my decision, which indicates that there were two people involved, not just the decedent.
Is it your testimony also, in your medical opinion, that someone can have a, quote, vigorous verbal argument and that would sustain a finding of manner of death such as you've made in this case?
Yes.
But doesn't the literature that you've quoted so much talk about homicide and heart attack doesn't include just vigorous verbal argument?
No, some of these documents do say that it can be
Show me
pure.
a document that says that.
As we've discussed in the name guidelines on page 13, that paragraph 28, deaths resulting from fear/fright induced by verbal assault.
And you mean that's just a verbal argument?
Yes.
Let me ask you this before I forget again. So I'm going to give you a hypothetical.
Okay.
The two people, Mr. McGee and Mr. Savage, were having a discussion that escalated into a verbal argument. And Mr. Savage became belligerent. And assuming for the next fact that he told her to get out of the house, and he pushed her against the living room wall. And assuming the next fact, and hypothetical, he continued pushing her several times, pushing her into the adjacent kitchen dining room area. And for the next fact, for this hypothetical, he pushed her into the kitchen table, which resulted in several plates being knocked off the table and broke on the kitchen floor. The next fact, he then pushed her into the kitchen refrigerator, grabbed her by the hair, and began to push her down the hallway towards the front door. And the final fact is, when they entered the front hallway, Mr. Savage fell and collapsed. Based on that hypothetical, is it your opinion then that the precipitating event that resulted in the cardiac event at issue was not Mr. Savage's own anger and his own conduct and assaulting Miss McGee and pushing her into a wall and then pushing her into the kitchen and then pushing her into kitchen appliances and then pushing her down the hallway? And while he's pushing her and grabbing her hair, he collapses. Are you saying that it's still somehow she's responsible, she's the precipitating event?
Yes, per the medical definition of homicide.
Oh, this
Wow.
got me. This got
Wow.
me because she also, by the way, admitted that she did not review the victim's medical records beyond the ones of the night of the incident at the hospital. She never listened to the 911 call and maintained it would not have changed her opinion anyhow because of that. This, I agree with Disney Nerd, his opinion here. This is scary. I would love to know what my husband thinks about this because I know that, if you rob somebody, you have somebody, you're in the middle of robbery, you're getting robbed and somebody puts a gun at you and you have a heart attack, you could be charged with manslaughter. But this, come on. I mean,
Yep.
come on.
And that's what Judge Bev seemed to
I
say
have an
today. Come
argument
on.
with you, and you go ahead and have a heart attack. You come knocking at my door talking about arresting me for manslaughter. I mean, there was no way Beverly Cannone was going to rule that she was guilty. No way. Massachusetts does not like setting precedent. Thus is the reason why we have these old laws. But like I said now, if I was in that situation with that same set of facts, and it was Judge Beverly Cannone, I would have took a bench trial because I'm going to tell you why. She's going to follow the standard of the law. Rather than giving that to 12 people to be all confused and not understand what in the world was going on and get all emotional behind the daughter's testimony, that would have been a total injustice.
Well, I'll tell you what, Joanna, you've been great bringing it to our attention, and for the next town over in Stoughton, the Birchmore case with my husband is involved, and they couldn't figure out that somebody's death was a homicide. When they called it a suicide, really, and here they're calling somebody whose hair is being pulled, bringing down the hallway, and he has a heart attack.
How dare she be heavy enough that it caused him stress and he had a heart attack?
It caused him stress.
And she's really petite. She might look a little bit bigger from on the camera.
I was being facetious.
A very petite woman, and her husband seemed to be a little bit larger than her. So who's winning that battle if he's grabbing her by the ear? He's full of age. Like I said, he might have been a good man and a good father, but he definitely got angry, and that probably wasn't the first time. And he was in car accidents.
It doesn't matter. The medical examiner is the one who's supposed to be the barrier between something bad happening and this.
It's like she's a frustrated attorney or something, because she just took
that
leap from medical examiner
to psychic
cause of death to, oh, maybe this is actually a crime. And I fault the prosecution for doing that.
She knew how he felt before he died. And well, I just felt the medical examiner to be very nervous. And so there was
nervous. I think she was like this is my opinion, and I'm not changing it. And
was
yes,
very
by the
cocky.
rule, by what the National Association said, this is it. And if there's another person in the room who says, boo, and you die, boom.
The first day I watched her with my favorite cupcakes, and I felt the same way about her. I kept thinking, oh, I could just smack that Boston attitude out of her, you know. But then when I saw her in the court, when I saw her in the courtroom and I watched her testimony, she was very nervous. And I tend to get a feeling, and sometimes when I get a feeling, I like to really not say nothing. But she was very nervous, and it made me think back to that testimony with Larry Tipton saying that the MS police officer, trooper, I can't remember his name, was in the autopsy room. But every time he asked her if she had a conversation with any said trooper, the answer was no. She came off very strange to me in that way. And I don't know what's going on with Mass State Police, but I'm sure you all know that that's a big problem here in Massachusetts. They stay in a bunch of mess. And reason, I think, in my own opinion, is because in Massachusetts, it's always been about who you know. Yeah. And so with this case, you even have to go far as back as to think about the politics of this whole case. The daughter had a connection to Suffolk County District Attorney Connolly. Okay.
Yeah, and he was a big Democrat at one point here. But you know what, Joanna? We're going to have to say goodbye to you tonight. We're going to, not forever, but just tonight.
No, this has been nice.
We think that this is so great that you brought to our attention. We hope you come back and go in the chat. And we thank you for coming on the air with us so that you know, as we've been trying to do, we've been trying to showcase some of our viewers, by the way. We started out.
I appreciate coming on with you guys and giving you my little insight. And I would just say, if everybody could go follow Melody Little, if you haven't, she's a great commentator as well. And I'm sure you guys would love. You should actually ask her to come on your show. She would be great on your show.
Yeah, that'd be great. Terrific idea.
She would be great. But thank you for the invite. It's been nice hanging out with you guys.
Thank you. Come join the chat. Come back.
I will.
Okay.
We'll see you next time. Thanks, Giovanna.
Okay. Bye-bye.
That's great. That's great. Get some inside info from, the folks who take an interest in this stuff, not because they're connected to it, but just because sometimes
you're going to have to send me that clip, by the way, so I can show my husband and see what.
The Emmy cross.
The Emmy cross.
That's only a little less than 5 minutes, and you get the sense of what's going on, right?
Everyone wants to know what Michael's opinion is.
I know.
I'll see if I can find out.
Get some pillow talk for us, would you? We'll figure that out.
All right, but now we're going to move on to the case of. Oh, that case. They think the case of ASAP Rocky, Michael, and you would think that, let's see, we have a dismissal, directed verdict in Georgia. We have a not guilty here in Massachusetts. And now we're back to ASAP Rocky, where Joe Tacopino tomorrow will continue his cross-examination of the case agent who seems to have made their case for them. Let me just remind you where we are before we bring Neil Rockind back in. Rockind Neil, who co-hosted Rockind co-hosted. You were Rockind when he co-hosted the other night. And he was talking the shell casings, right? We've got the shell casings now not being at the scene. We have Relly never going back to the scene, right? To supposedly
not seen on the video. Yes,
that's seen on the video. The officers didn't think he was on the video. Then they thought, well, if that could have been on the video, it was only 2 minutes, but that really wasn't him. And now we have the fact that they know that he was shooting a Glock in both New York and New Jersey, and we've heard all of that. So the case agent was like. To me, when I was listening to the case agent, I was like, where are we going here, including the search, 25 people to search ASAP Rocky's house to find guns that he legally owned and guns that were owned by other people, right. Which means that even if there is a magazine for a Glock there, it could have been owned by somebody else, not just him. But anyhow.
Could have been. First, before we move on, thanks to Here Comes Drama, gifting the Justice Served membership. We appreciate that. And before we move on, one question we didn't quite get to that I want to do before we get into the Rocky stuff. Okay. You can't die from someone yelling at you. I'd be dead most of my life, allegedly maybe, I think probably says what we all believe, right? Anyway, so that was, sorry, a little side trip.
No, that's
Let's
great.
get back to Rocky.
No, that was great. I mean, I'm going to keep saying boo every time somebody comes around the corner. And God forbid it's in Massachusetts, because if they die, I guess I'm going to be charged with manslaughter, and I'll have to call you guys. So let's get back to Rocky. Let's bring Neil on.
There he is. I found him. Hey, Neil. How you
Hey
doing?
there.
Hey.
Hey, you got more dressed up for when Linda's here. What's the deal? What's up with that?
Still no Chanel and
well, no, that's
I
yeah.
know. I made the comment the other day that I had big shoes to fill. In the meantime, I recognize I probably have much bigger feet than Linda, but I'm sure that my shoes are not nearly as nice.
No,
Well,
yeah.
yeah, but Michael's now wearing red shirts. Pretty soon we'll see Michael in red Louboutins for men.
I don't know. I don't know about that. I don't know about
He's
that.
trying to match the chair. Red, red and red. Right?
Yes, exactly. Yes.
All
right, so Neil, we have a
Yes.
question, and you guys are going to talk more about this than I will. Why won't the judge issue, or will the judge issue, a directed verdict on this case? I mean, that's certainly a way to save the prosecution if you think that this case is marred, especially when the guy wants $30 million. But to get that bag of $30 million, you got to have a lawyer, because or else they call it extortion. So I just go back to that. It's whoa. That's all I can say.
You know what's interesting? So what's really interesting is that the most significant evidence in the case came from John Lewin's cross-examination of Wally, who was essentially testifying about audio tape that he made with Relly that Relly said wasn't him and was AI. So John Lewin did, I mean, look, we all, John is a bulldog. He's certainly an aggressive prosecutor. But he went after Wally. And in some ways, if you were just reading the black and white of it, it could be considered at times that it was compelling at times. The challenge is the jury reacting to it? And is the jury care? Because does the jury care? And again, I'm not saying whether Lewin that he did a bad job cross-examining Wally, but he's cross-examining a witness who was called to literally say, I didn't manufacture and fabricate these videos, these audio recordings. So he spent a half an hour, maybe longer, an hour or 2 hours, whatever it was, cross-examining Wally, drilling in that Relly said this, Relly said that, Relly said this. But Relly himself, who's the state's witness, said, that was AI, it wasn't me. So
that's kind of a lie, right?
Well,
that's a lie.
It's clearly a lie. And the interesting question that comes out of it is, can the state pull back? Can it? When I was talking to Michael the other day, we were talking about if you could assign value, numerical value to a witness, if there's only 100 to be gotten total, what would you give Relly's testimony and his credibility? 1 is the worst you can get. So if you're the state and you start off with your witness at a 1, the best you can do to try to pull that witness back from the 1 yard line more towards the center is to cross-examine the heck out of somebody who, in cross-examining, you have essentially proven that the witness was lying. I mean, all the cross-examination did was show that these guys are, maybe neither one is ultimately reliable, but only one of them is the one that the state has to hang its hat on.
Yeah, we kept talking
about the directed verdict point. Is that I wanted to just tell you that what's so interesting is one snippet where Joe asked the lead detective again and said to him, "Is there any evidence on that video of a gun being fired, of a weapon being discharged?" And the answer was no. And this is a case not about possession of a object that looks or is fashioned like a weapon, or an object that looked or appeared and seemed like a weapon. This is a discharge of a firearm at somebody case. And you got a lead detective saying, I don't see any evidence of it on that video. We have no evidence of the slugs, no evidence of the shells, no evidence of bullet holes in a fence, in the ground, no ricochet in a nearby car. So, you know, it begs the question, when the police found out about this case, did anybody go back and even attempt to find anything at all that you're telling me, if there was a bullet hole out there, nobody went back to go look for it or find it? Nobody found one. So there is very little that pulls Relly's testimony back from the depths of between the 1 and the 10-yard line.
Yeah.
That
So
was
then,
that
go
was
ahead.
the question we had, was that, you know, let's assume best case scenario, he's worth 10 points, you know, as a witness. Who is going to lift him up in a case where his testimony is, in my opinion, the only testimony that's going to mean much in the long run?
None.
So yeah, none. So the Torres, he's not saving the day, you know. I just don't know, Linda, who's coming in to rescue this case?
Nobody. I think the lead detective. I think that Joe converted him to. I don't know why they waited him for last. I mean, I think Joe converted him into the defense witness. To me,
Defense witness. That's the
defense
ultimate.
witness.
And by the way, for those who don't know, that's the ultimate compliment you can pay a defense lawyer, is taking a state's witness who was put up there with the intention to help to sink the case or to make the case for the state, and converting that witness to your own witness. And I thought Joe really, from what I saw, did a pretty good job with the state's witness.
What I thought was good too about the cop was he seemed very even-handed. He didn't sound like he's there to, you know, promote the prosecution
Right. He
or the
wasn't trying
defense.
to trying to
you
push
know,
an agenda.
He's what I
Right.
call a dragnet witness.
So one of the things that which we don't give juries maybe enough credit. I just had a case that just finished where the jury literally said to the prosecutor, after the jury was out 10 minutes and then, you know, acquitted, went back and talked to the jury and for a minute just to thank them. And the jury turned to the prosecutor and they were like, what were we doing here? This was like a waste of time. Now, I'm not saying that shootings are a waste of time, but when you take it together, Relly went back to the East Coast. He went back to the East Coast for medical treatment, allegedly. He has wounds on his knuckles that look like he scraped the ground. His wounds are less serious so than I've gotten if I happen to brush my arm up against some, you know, a brick wall. They do not look like a bullet graze. How would, and Linda, you would know this better than anybody, you and certainly your husband, Michael, how would a bullet graze all of the knuckles, right?
Right.
I mean, how?
It's a miracle, Neil. It's a miracle.
I mean, you can't even, I mean, maybe I'm getting old and I'm a little arthritic. I can't even get my knuckles to align in a way where my forefinger and knuckle and my, I mean, how?
It looks like a punch. I mean, to me, it looked like he fell. Or he fell and it's great, or it's great, whatever.
It's ridiculous. The directed verdict. So this would be a saving.
Let's explain to our viewers what a directed verdict is.
Okay, so a directed verdict is at the end of the state's case, the defense can move for a directed verdict. And what the standard for a directed verdict is exceedingly high. It's as high as it gets for a judge to grant it. It is called a directed verdict of acquittal. It is essentially the judge looking back at the case and saying, I look at the evidence that the prosecution presented. I take it in a light most favorable to the prosecution. That usually is the death knell of directed verdict motions. Right. But saying that I look at it in the prosecution's best case. I take their very best case. I look at it and I decide whether or not this case, a reasonable juror or any reasonable jury could find in favor of the prosecution based upon that evidence. They are very rare. I'm sure Linda's won more directed verdict motions than me.
No. I don't even think I've won one.
What's that?
I don't think I've won one.
I had one, and
it was career. Right.
There were like 8 counts, and we got one out of
Oh
the
yeah,
8.
that I've
The
had.
prosecutor wanted.
Yes,
This
that
is
I've
the
had.
kicker. Then, and the prosecutor wanted to appeal. Wanted the judge said, I'm granting a directed verdict on count 13, and that was the toughest count for my client, and we were all high-fiving, and the prosecutor goes into, hey, judge, you need to, judge, I want to stay it. I want to argue it some more, and I want to stay it, and I want to go to the Court of Appeals. And we were like, sorry, man, that's double jeopardy. The judge has directed a verdict of acquittal. It's not like you can't stay it and appeal it, at least not in Michigan. So if the judge, are there some facts, and this is something for your viewers to analyze, are there some facts taking away, looking at the state's evidence in its best possible light? Does the state have any case at all? Just be in its best possible light.
I think the only way you get there is if you believe that Relly was not lying. Because if he comes off as having lied about so many details in this case, then you can't get there. You have to believe that somehow he's telling the truth sometime when he's talking about the details of the incident, and he's lying at other times. And the court's going to have to make that decision that no reasonable juror could find that he was truthful about the facts of this case.
Now, it's not even just truthful, that believable. Let's say believable versus truthful, right? Because the standard is, could a reasonable jury find Relly believable beyond a reasonable doubt? Forget about truthful. I prefer to say believable, because believable, that there's a standard there. Is he believable beyond a reasonable doubt? So here's my question. I am aware of only a couple of cases, and I was trying to quickly try to find them as we began our conversation just now, where judges have made findings that witnesses, and typically informants, where a judge has made a determination that a witness is just not believable, is so unbelievable that he can't even cloak it in the witness has in a light most favorable to the state. And Michael, I take your point to sort of mean that, which is, it's not like Relly was caught in a couple of lies or a couple of misstatements about one point. He flip-flopped back and forth. You would have to carve out little pieces of his testimony and then attempt to glop it together and say that it's believable. That is a very tough, that's going to be an interesting test for the judge. I assume that's how Joe's going to argue, and I'm interested if that's going to be an interesting test for the judge. If he sticks to the traditional, I'm going to let the jury decide, then he's probably going to deny the motion for a directed verdict. But if he's surgical about it, if he really wants to get into it, and he thinks that Relly lied to the jury, like, that's another question. If the state's witness lied to the jury, and the judge believes that the state's witness lied to the jury, can you send the case? Because now it's a concession that the witness lied. If the judge concludes that, can you send that case to the jury?
And that's where I'm having an issue here. Even when I can understand they took the case, okay, although I think I'd have certain problems taking the case when somebody comes and says, I want 30 million, and then comes and says, I want 30 million, give it to me in cash, because, I got to do it through a lawyer to get that bag, and I'll disappear. So the prosecution will never find me, right? I'm going to disappear, and they'll make it very difficult to you. But I think you get to the point where, aren't you suborning perjury if you are a prosecutor? Isn't that a consideration you have to think about? And if you're a judge and you think that this witness lied over and over again on the stand, how can you, as a judge, then let even a jury decide it? Don't you have to take it away from the jury and say, no, I'm not going to let this go? And our reporting has indicated through double sourcing 2 different times that the judge at first had some questions to the prosecutor about whether they continued the case because of ethics, and whether they could continue the case. And we stand by that reporting. Now, let's assume that's true. There's people arguing that, no, he wouldn't have said something like that. But let's assume that's true. If the judge has had that, and now we see Relly lying, and we've all agreed they lied. The whole AI thing, lie. I mean, it's not me, because he knows he doesn't want to be seen as extorting money, right? How could a court let this go to a jury?
So the way that you obviously framing issues is very important. I think the way that you frame that issue, Linda, it really is probably the best case for the judge pulling the plug on the case, which is that if there's a concession or it's clear that the witness lied a number of times, lied about something significant in the case, and how can you, I mean, it's indisputable that the witness lied if that's the position and the judge felt that there was a question. Let's again, just assume, again, I wasn't there, just assume that the judge did raise that issue with the prosecutor. The judge raises that issue, then essentially saying, well, I'm going to let the jury decide, means that at one point you're thinking that this could be an ethically challenged prosecution based upon someone who's committed perjury on the witness stand. But at the same time, you're going to let a jury decide the case. That's a conundrum.
Yeah, I would not want to be wearing the robe in this particular case. And we talked about it, Neil, how it really, the prosecution in a way should be hoping that he does that, because it really lets them off the hook and protects them from whatever might come in the way of misconduct charges or an investigation. Then they can say, well, the judge did that.
What's interesting, though, is you have two different, and you guys have commented on this a lot, and I've heard you've been, I think, very complimentary about the style and approach of the lead prosecutor, who comes across having the attitude of someone who is, hey, I'm just here to put my case on. I'm going to put it on. Whatever happens, happens. I'm sure he has a belief about the case, but he's not twisting anything, right? He's just believable, likable. That's really, in my opinion, the best type of state's attorney to have, is someone who's believable and because they represent all of us. They represent the entire state. So if he's doing that, the question is, would he think that is acceptable? Now you got John on the other hand. John is,
it's Mr. Lewin, that's John Lewin.
Mr. Lewin. John is pressing ahead. I'm just going to go back to, I think a directed verdict in some cases can have the effect of taking a lot out of the hands, taking it off the prosecutors. Hey, you gave it your best shot. You gave it the case. You tried. You put forward your best case. It's not your fault. Your witness stunk. So, but I'm not going to put the defendant, I'm no longer going to hold him in jeopardy for this. Directed verdict of acquittal. You're also telling the jury, like, look, I couldn't let you decide this case. I can't let a citizen's case get to this point and get in front of you. It would save the prosecutors the potential of having to, face this potential issue, which is, can you argue credibly to a jury what we believe as lawyers, the four of us, is not arguable, which is that Relly is not a believable witness. Yeah. Can you ask the jury to believe something that is demonstrably something that you can't believe?
Neil and Michael, because I really want both of your opinions on this, because you're both watching. The prosecutor was supposed to, I think, made a problem. They were going to call other people that were at the quote, the shooting. They were going to call the girlfriend of Relly, who supposedly was there when he picked up the shell casings. They didn't do any of that. So now the only one who can testify to the shooting is Relly, it seems.
Yes.
Right, Michael?
There are very little forensics, right? It's almost negative forensics. It's like, it looks like nothing happened there. Nothing.
There are none. And the idea that nobody's gone out of, if there are supposedly 4 or 5, you're telling me there was a rumor, right? These are things that I might potentially argue if I were Joe Tacopina, but there's so much to argue in this case. It's like, Judge, can I have 3 days to close? But there's an allegation of a shooting by one of the top pop stars in rap, who's married to one of the most famous, most sought after, photographed, desired, artists actors. You're telling me that nobody else has gone out there to try to find these slugs, there were 4 or 5 shots. So Relly found 2, allegedly, right? You're telling me that since then, there are people who go on the beach every day with metal detectors looking to find someone's old can opener. They're looking to find an old coin. You're telling me nobody out there has attempted to find a slug? Nobody has found a hole or a slug or a bullet that came from the sky or something in a tree? Nobody anywhere, period. This guy Relly was that good at this that he and his girlfriend, who wasn't on TV, wasn't on camera, happened to find 2 smushed slugs, but nobody else did.
Yeah, he was Inspector Gadget.
I mean, I find that very hard to believe. That creates a lot of doubt for me.
Of course. Thanks to Madeira Beach caregiver. Can't wait to hear the story because you disappeared for a while and now you're back, and we're glad you are. And Jerome Street, also thank you for your membership. Hey, let me look at this poll because we've been talking about Relly and we're talking about, the blowback that he's received from anybody watching this. So we put up 2 questions on our site on the community tab. First one is, do you think Relly was trying to extort money from Rocky? 98% yes. Okay. It's a pretty good sample size too. It's hundreds and hundreds of votes. And then if you think he was trying to extort money from Rocky, should the DA have charged Relly with that crime? Only 92% say yes. So it dropped off just
that brings
that
me
tells
to my
you,
yeah, right.
There's the jury, there's the jury voting.
But let me ask you both. But that doesn't that go to the ethical issues then? You made a choice, DA, and it was the previous DA, I assume, that made the choice. Because remember, Gascoigne is right. He's gone, right? It was Gascoigne's office.
Gascoigne is gone.
Gascoigne is gone. You made the choice to charge. They made a choice of who they were going to believe, right? They made a choice. It sounds like they made a choice. They wanted to go after and get, as we used to say, another notch on the gun belt, right? In terms of going after the high-profile person. So with that choice, though, they had the choice to make the other side, to charge somebody with extortion, and they don't. Who made that choice? Who exactly was the one in the office who decided that? That's what I want to know. I mean, I think that's an important thing to know. I think that if you want to have transparency, let the DA not only ask for the removal of the gag order that they asked for, but come down and explain who made that choice, why they made it, why, what went into it, and are they having any repercussions? And is there something in that office? Do they have a I know they have a Brady section, but do they have an ethics violation section? Do they have something that can review it now as we sit here today and see what we've seen?
I don't know the answer to that. I'm always worried about crossover prosecutions. We've seen those in the past. In Michigan, we dealt with Jack Kevorkian being prosecuted back in the 90s, and then when prosecutors came in replacing Jack Kevorkian, they made a decision that just because the office was bringing the case against Kevorkian, they decided that they weren't going to proceed with those cases. They just made a decision that as the elected prosecutor, you have the right to make a decision, whether you decide that it's ethical or unethical, whether you think that it's a good case or a bad case, whether you think that the complainant should be charged with extortion or not. You have the ability, right, to just say, I want to do a hard look at these cases that are coming up for trial in the first week or two of our administration. I want to see the cases. We don't have time to do a full vetting of these cases. I want to see the first month's trials. I want to see these cases on my desk, and I want my I want my review team. I want to see them, and I want to look at them, and I want to know, are these competent cases? Are they strong cases? Are they weak cases? I don't want to start off my term as the elected prosecutor with cases that are already potentially giving us a black eye.
That stink. Here's why, I think that accounts to some degree for Lewin parachuting into this case, after the first, about a month after Hochman took his job. But here's what I think. This goes to your question, Linda. Most of the time when you ask me a question, Linda, and I don't know, I'll say, oh, is that a rhetorical question? But here's my take on this. Nobody talked to Relly to the degree they needed to determine whether the guy's full of crap or not. Nobody in the office, whether it was because there was a transition taking place, maybe because Lewin was coming in and Pauly P, decided I'm not going to do that. It's not my job. I don't know. But the fact is, it's clear nobody in the prosecution's office talked to Relly P.
Negative prep.
By the way, thank you for gifting 5 memberships. Thank you.
Negative prep, the opposite of prep.
Dira.
Yeah.
See, we oftentimes call what prosecutors will do to witnesses, we used to call it sanding them, right? They would take the witness and they would take sandpaper to them and try to smooth out all the rough edges. And we hated that because, you don't want we like the witnesses, the state's witnesses, when they get on the stand and they're not totally prepped. But we're also prepared as defense lawyers, all of us, for a witness that's going to have had some prep. In some ways, it was almost like Joe came loaded to bear for a witness who was going to not fight with him physically, which it seemed like was almost at times going to happen, but a witness who would be a little more savvy and instead just, at one point, what do you call it? Called Joe Tacopino.
He just said, like Rockind. Hey,
you're slick.
You're a liar.
You're a liar. You're tricky. Right? There's one moment that I hope Joe does capture if he's forced to close this case. And I want you guys to remember this moment. Sometimes it's when a witness catches himself in a dialogue, in a monologue, and they catch themselves and they stop, that you get some gold. Right? There was a point at the end of his questioning from Tacopino where Relly, he was kind of riffing about about how unfair this was, and he didn't want to be here. And he actually said, he began saying, "This isn't what I
signed up for." Yeah.
Right.
Now, he didn't finish that sentence, but boy, if we could imagine what he was trying. This isn't what I thought it was going to be.
Mm-hmm.
I thought I was going to get up here and just tell my story, and it would be the end of
I get my $30 million.
Yeah.
And the civil suit.
that moment.
Yeah.
And then the second, the judge just repeatedly telling the guy, I have yet to see a judge, stop, you're not helping yourself.
Yeah.
So I go back to the directed verdict that we saw being made in the Georgia case today, and I bring it back to you again. Michael Bryant first and Neil second. With all this, how can this judge say, I'm going to put it in the hands of the jury to decide? Does that help the prosecutor any, or does it help the prosecutor more to say, I'm stopping this right now?
Yeah, I mean, there's no doubt that if the judge throws the towel into the ring, and stops it, it helps the prosecution because no longer are we looking at them for what they did, should have done, might have done. Sources tell us they have done, but the judge has made an independent ruling, and it really lets them off the hook. And in a weird way, I can't imagine any prosecutor, certainly not Lewin, thinking, "Boy, I hope they grant that directed verdict," because
they like you, Neil. Jerome
it's close.
Neil's on point. Love this guy. If you were the victim, you'd get that $30 million in the civil suit.
So you're asking me. I think that in some other cases, smaller cases, I think the judge, it was his courtroom prosecutor, his regular guy, the line prosecutors that are in there. I could imagine a circumstance where the judge looks over at the prosecutor and says, I'm granting a directed verdict. And then after he does it later on, pulls the young prosecutor inside and says, look, I just did you a favor. Like, I granted the direct, I just did you a favor by not having this case end up going to the jury and having to have them decide this case, and et cetera, et cetera. Do I think that's going to happen in this case? I don't. I think the judge is going to let it go to the jury. I just think that I saw a couple of moments where the judge felt, you could see the exchange between he and Lewin. It got to the point where Lewin was actually trying to tell the judge, we actually got some, what's the dude's name again? Was it Brooks? What's his name?
Daryl Brooks.
Daryl Brooks. We got the grounds.
Yeah. Yeah. Well, Lewin was.
Lewin actually, I want grounds, and we lawyers in court, we argue, we make motions, and we argue objections, and the judge says, "Well, Mr. Lewin, what do you want? How do you want it to be?" I just don't see the judge, as much as I just don't see the judge in the end granting a directed verdict. I think he could, and I think that he likely won't.
Well, we may see soon enough, because very good chance that will unfold tomorrow. They're back at 10:30.
But I am going to say I think that that Joe and they've acquitted themselves well out in California. I know that John made it seem like in California there's something extra to making objections. So this is not how we do it in California. But Joe's tried a million cases, and it was clear the judge understood that. And I mean,
I thought Joe did a brilliant job. I tell you, because everyone's Joe Tacopino. I thought that he was restrained at times. I thought he built his case. I thought he did what we teach at Harvard: is take the building blocks the prosecution has, knock down that wall, and then rebuild them slowly, one at a time, into his story. That when he had to be hard, that he was hard, he maintained his ground. But when he had to pull back, he did pull back. I just thought he did a brilliant job so far. No matter what the outcome.
Something else. I look at Joe. He's being himself. Now I know the people say lawyers should be themselves, but we all have a variation of ourselves, right? We've got our difficult self and our snotty self and our bratty self and our angry self. We all have those versions of ourselves, right? But I think he's being who he is. I think that's who that is his personality, right? I mean, and I think that and he's told some jokes in there, and he's had some, and I think there's a couple of moments where he was exchanging some camaraderie with the judge and with joking about the cough drops. Remember with the jury,
Right,
ours are better.
Right.
Yeah.
Right.
By the way, Brooklyn, it was John Lewin who requested the gag order. It was the prosecutor,
Yes.
and they can unrequest it if they want to prove us wrong and let their office and let Tacopino's team address what we have reported.
Hey, let me just say one thing before we wrap up here.
Yep,
As a
yep.
California attorney, Lewin is not how we do it. Okay, so Lewin may think that he's speaking for all California attorneys. He ain't. I'll go with Joe. So.
I thought Joe has been himself. He's the same person outside as he inside. I think he's shown different speeds. I think that he took on clearly the entire case. Here's something else you can tell why the entire case was rally. Want to know how I know that? Because the only witness that the witness that what's his name was objecting to and trying to stop Tacopina from bulldozing, the only one that Lewin was involved in objecting to Joe's cross of Relly, right? I mean, that's the rest has been the other prosecutor.
And
So
remember
clearly that just
how that was set up, from day one when they had that weird conversation with the court about, well, if one attorney is doing the examination, and is it okay to have the other attorney objecting to the cross? Weirdest thing we've ever seen, and there we see it play out. We know why.
that just shows you how important Relly was. They were going to put their defense had their A guy, A1, and the prosecution wanted to make sure Lewin couldn't get up to speed to direct examine Relly. My guess is he just doesn't know the case in and out like you want someone to know the case. But when it came time to object, he was the one who was going to put a stop to Tacopina. Was that, and only when it came to that witness. That's how you know that witness was the entire case.
Yeah.
Well, we may find out tomorrow what happens, or Friday, because I think it's been reported that this is the last witness that the prosecution's putting on. And we're going to be covering it. We're going to be here at lunch hour when they break. And then tomorrow night at 7:00. We're also going to have Doug Weinstein back tomorrow night to talk a little bit about what happened in that Georgia courtroom. But we think that tomorrow and Friday, we may be calling you back because there's going to be some fireworks.
This is an unsolicited plug, but you guys are so great at this, and it's great that there is a place for I love when Linda would host Law and Crime because she was herself, not reading off the cue cards. I remember when they wanted her to read off the cue cards one day, and she's like, I now have to read off the cue cards. But she's herself, and that is what makes her so authentic. And Michael, you're so great at this. It's just great to have you guys on together, just as you are, and just able to kind of freestyle. So it's awesome.
No, we appreciate that, because
Awesome.
that's all we're doing is just, we're passionate about this stuff, as you are.
Love it. Love it.
And if we can, inform some folks, entertain some folks, then good for everybody.
All right, guys.
Thanks,
All
buddy.
right,
We'll see you
thank
again
you.
next time.
You bet.
Take
You bet.
care, man.
Thank you.
Bye.
Okay.
All right. So tomorrow, big day again. Back in court, 10:30 in the morning Pacific time, 1:30 here. We'll do our little lunch chat, I suppose. Are you available for that?
Yeah, I should be available. I have to go out at noon for a very quick appointment for probably will take less than an hour. So it's only 1 o'clock here. So they're not even going to start.
Yeah.
Probably right.
Yeah, 3-ish, 3:30, whenever
Yeah,
the break
yeah, so we
is,
should
we'll be
be
on
here.
to fill that hole and
Yeah.
see where we stand. And who knows? Could be talking about directed verdict. Who knows?
Who knows? We
Who
don't know
knows?
where we're. But tomorrow night we could be talking about directed verdict or non-directed
In the other
verdict.
case, yeah.
One way or another.
And Doug Weinstein will
Yeah.
be joining as well.
Yeah,
So
and Doug
that'll be
Weinstein,
fun.
yeah.
That'll be tomorrow in the post party, I think Missy calls it. The post trial party. Okay, well, I can't wait to see what happens. Good to see you again, partner. I'm Michael Bryant. Hey, trying to do the right thing.
I'm Linda Kenney Baden, and together Michael and I are Justice Serve TV. And if you like us, please hit that subscribe button, share, and that notify, and we'll see you tomorrow afternoon.